Hit that like button like you like something. We gonna read this. If I mess up, I don't care. Go find somebody else. I don't know how it's going. In the Court of Appeal of the State of California, Second Appellate District, Division 3, the people, plaintiff, and respondent versus Daystar Peterson, defendant and appellate, appeal from a judgment of the Superior Court of Los Angeles County, David V. Hereford judge. We're just gonna skip all this other stuff. In December of 2022, a jury convicted Daystar Peterson of assault with a semi-automatic firearm on Megan Pete, carrying a concealed unregistered firearm in a vehicle, and discharging a firearm with gross negligence. The court sentenced Peterson to 10 years in a state prison. On appeal, Peterson contends the trial court committed a number of errors. We find no judicial error and accordingly affirm Peterson's conviction, meaning he's guilty, sit it down, prepare to thug it out. Facts and procedural background. So everybody who wants to argue, that's fine. But listen to this before you get to going crazy in the comments, please. Peterson fires 5 shots at Pete, striking her in the feet, meaning both feet were injured. On July 12, 2020, Pete went to a gathering at Kylie Jenner's house. At some point, Pete texted Peterson and told him to come. When Peterson arrived, it was really late. Eventually, Pete wanted to leave. Pete, her friend, and personal assistant, Kelsey Harris, and Peterson got in an SUV driven by Peterson's driver, Jaquan Smith. An argument started about the relationship among Pete Harris and Peterson. So that's all 3 of them. Pete asked to be let out of the SUV. Pete got out and started walking away. She heard Peterson say, "Dance, B. It's way too early in the video, so I can't say the B word right now." Pete turned her head a little bit and saw Peterson pointing a gun at her. She froze. Pete heard shots. She looked down at her feet and saw all the blood. Pete dropped to the ground and crawled into a driveway. Pete felt pain in both her feet. After that, it got blurry. Pete saw Peterson and Harris walking towards her. Peterson started apologizing. Pete got back into the SUV. They heard police sirens and Peterson told Pete and Harris, "Please, y'all, don't say anything. I'm about to sign a big deal. I'll give both of you $1 million each." Oh, wow. At 4:27 a.m., Harris sent a text message to Justin Edison, who handled Pete's security. The text said, "Help. Tory shot Meg. 911. Police stopped the SUV. They asked everyone to get out. Pete told the police she stepped on glass. She didn't tell them she'd been shot. When asked at trial why she told the police she stepped on glass, Pete referred to the then recent murder of George Floyd. Pete testified she didn't know if they're going to shoot first and ask questions later, and she didn't feel safe with police officers. Officers found a 9mm Luger semi-automatic handgun on the floorboard of the front passenger seat. The gun was in a slide lock position, meaning all the rounds had been fired from the magazine. Wow. It was warm to the touch. Even though it was cold outside at that hour of the morning, officers also found a bloody towel in the back seat. The officers took Peterson, Harris, and Smith into custody. At the station, officers checked the hands of all 3 for gunshot residue. The samples taken from Peterson and Harris were positive for gunshot residue. A criminalist testified at trial that if Harris had been standing within feet of an individual firing a firearm and came into contact with that individual after he fired a firearm, she would not be surprised if Harris tested positive for gunshot residue. No gunshot residue particles were detected on the sample taken from Smith. An ambulance took Pete to the hospital. Neither in the ambulance nor at the hospital did Pete tell the medical providers that she'd been shot. She later explained, in the black community, it's not really acceptable to be cooperating with police officers. Pete also said that when a woman accuses a man of something, people have a hard time believing you. She added, this whole situation in the industry, like a big boys club. Like, I'm telling all y'all friends, and now everybody about to hate me. Around 9:05 in the morning of the shooting, Peterson called Harris from jail. A recording of the call was played for the jury. Harris told Peterson that Pete was still in the hospital and she was outside. Peterson said, "I know she probably never ever gonna want to ever talk to me again, but bruh, I just want you to know, bruh, nigga, I was so effing drunk. I never do some shit like that, bruh. You know, regardless, that's not gonna make anything right. And that's not gonna make my actions right, bro. But I'm just deeply sorry, bruh. So, like, I feel crazy, bruh, but made a mistake. Like, what happened already, bruh. I can't take it back, bruh. I'm just telling y'all I'm sorry, bruh." At 8:59 p.m. that evening, Peterson texts Pete. The text said, Meg, I know you probably never going to talk to me again, but I genuinely want you to know I'm sorry from the bottom of my heart. And I was just too drunk. Nonetheless, shit should have never happened. And I can't imagine what I did. I just feel horrible because I genuinely just got too drunk. I love you, and I hope you're okay. Peterson sent Pete other text messages, just apologizing. Pete had bullet fragments in both of her feet. She had to have surgery and physical therapy. Pete couldn't walk for a while. She can't really feel the left side of her foot. About 4 days after the shooting, Pete told police who had shot her. Pete testified she had a change of heart because Peterson had tried to start getting ahead of the story online. He put it on a bunch of different narratives what happened. DNA testing of the Luger revealed a profile of the last 4 people. Peterson could not be excluded or included. His contribution was inconclusive. DNA testing of the magazine also revealed a profile of at least 4 people. Peterson was not one of them. No usable fingerprints were found on the gun or the magazine. In response to the prosecutor's question at trial, Pete testified he was having a really difficult time sitting up there and trying to comfortably tell her story. Apparently referring to spectators in the courtroom, Pete said a group of people had been continuously spreading misinformation to make her look like a bad person. The charges, trial, and verdicts. The people charged Peterson with assault with a semi-automatic firearm on Pete, count 1. Having a concealed firearm not registered to him in a vehicle, count 2. And discharge of a firearm with gross negligence, count 3. And count 1, the people allege Peterson personally used a firearm. And counts 1 and 3. The people allege Peterson personally inflicted great bodily injury on Pete. The people also allege aggravating factors under the California rules of court. The case went to trial in December 2022. Among other witnesses, the defense called Sean Kelly. Kelly testified he lived near Nichols Canyon. In July 2020, Kelly was asleep. He was awakened by lots of shouting and voices. He looked through his window and saw 2 girls arguing. Then they started fighting. They were pulling their hair and hitting each other. It was quite violent. A tall man got out of the driver's seat of the car and got involved in the fighting. One of the girls went to kick the car. Kelly then heard what he first thought were fireworks. He saw a muzzle flash. At about the same time, a smaller gentleman got out of the back passenger seat. He was shouting a lot. Kelly saw more flashes and what was obviously gunfire. The muzzle flash was near the girls. Kelly did not hear anyone say, "Dance, bitch," although both defense counsel's questions and Kelly's answers were unclear. Kelly seemed to say the girl who was the aggressor went to the car and saw the muzzle flashes coming from her hand. Kelly then said the flashes came from the shorter man. Kelly testified, "I believe I saw the girl shoot first. They were both shooting." Kelly never saw a gun. He called 911. On cross-examination, Kelly admitted he told investigators that the short guy came out the car and then he shot the girl. The girl then fell into the road and started bleeding. When asked, what was he saying at the time? Kelly replied, a torrent of abuse. It was all just N-words and, F mother effer, and Kelly admitted he never mentioned a girl involved in the shooting to the 911 operator, nor did he mention a female shooter to the responding officer. Peterson chose not to testify. A jury convicted Peterson on all 3 counts and found the firearm and great bodily injury allegations true. Peterson, represented by new counsel, filed a motion for a new trial. The court conducted a lengthy hearing on the motion over several days. The court ultimately denied the motion. The court conducted a bench trial on the factors in aggravation under the California rules of court. The court found true aggravated factors that Peterson used a weapon in the commission of the crime and that the victim was particularly vulnerable. The court also found Peterson's conduct toward the victim after the incident to be an aggravated factor. The court listed social media posts, releasing songs with lyrics directed toward the victim, attempts to dissuade or perhaps give money to her and the other witness, and violating the protective order. The court stated, "I think this is a very significant aggravated factor in this case." The court added, "There were 2 times that he violated protective order where the court had to step in and raise his bail." The court found not true the prosecution's allegation that the crime involved a high degree of cruelty, viciousness, or callousness within the meaning of the rule. The court also found 3 mitigating factors: that Peterson had no prior record or an insignificant record of criminal conduct, that he had actively participated in charitable or philanthropic causes, and that he did not pose a significant risk of reoffending in a violent manner. Before pronouncing sentence, the court heard from 7 witnesses called by Peterson. The court also listed the authors of 76 letters it had received from Peterson's supporters. A prosecutor had read aloud a letter written by Pete as a victim impact statement. The prosecution asked the court to sentence Peterson to 13 years in a state prison. The court sentenced Peterson to 10 years. The court found the aggravating and mitigating circumstances were a wash. The court selected the midterm of 6 years on count 1, assault with a semi-automatic firearm. The court also chose the midterm of 4 years for the firearm enhancement. On count 2, carrying a concealed unregistered firearm in a vehicle. The court sentenced Peterson to the midterm of 2 years to be served concurrently with count 1. The court stayed under section 654, the sentence on count 3, discharge of a firearm with gross negligence. As to both counts 1 and 3, the court dismissed the great bodily injury enhancement under section 1385, subdivision, presumably in accordance with Senate Bill number 81, 2021 through 2022, Reg Stats 2021, CH 7211. Discussion. The trial court did not abuse its discretion in permitting the prosecutor to ask Pete questions directed to her inconsistent reports to police and her attitude about the case and about testifying. Peterson contends the trial court abused its discretion in allowing testimony and evidence concerning Pete's emotions about the incident and its aftermath. On direct examination, the prosecutor asked Pete questions about her initial statements to law enforcement and medical personnel that she'd cut her feet on glass. Pete responded, "When a woman says a man did something to her, people have a hard time believing you." Pete said she never wanted to come forward. "I didn't want to say nothing in the first place." Defense counsel objected to 9 questions along these lines. The court overruled 5 of the objections and sustained 4. On cross-examination, defense counsel repeatedly asked Pete if she lied. "You also on CBS were asked a couple of times if you had some type of sexual with my client, correct?" Answer, yes. Question. "You lied, correct?" Answer, yes. Question. "You lied on national TV, correct?" Answer, yes. Question. "You also lied to the prosecutors, correct?" Answer, yes. Question. "You also lied to Detective Strogner about his issue about the relationship, correct?" Answer, yes. On redirect, the prosecutor asked Pete questions that were follow-ups to areas defense counsel had raised. Pete testified people had been making things up and putting out different stories that weren't true, saying that I had never been shot at all. So, Pete continued. "I had to come out and say, yes, I was shot. I didn't just step on glass. I should have told the truth initially. I know that now. And I thought I was trying to protect people. I thought I was doing the right thing. I thought I was protecting myself. But in the long run, I wasn't. Relevant evidence is evidence having any tendency and reason to prove or disprove any disputed fact that is of consequence to the determination of the action." People versus Hardy. Even if evidence is relevant, Evidence Code Section 352 gives the trial court discretion to exclude it if its probative value is substantially outweighed by the probability that its admission will create a substantial danger of undue prejudice. People versus Thomas. The prejudice that exclusion of evidence under Section 352 is designed to avoid is not the prejudice or damage to a defense that naturally flows from relevant, highly probative evidence. People versus Jones. The Judas that Section 352 refers to is evidence that uniquely tends to evoke an emotional bias against a defendant as an individual that has very little effect on the issues. Lopez at P 504. In general, the trial court is vested with wide discretion in determining relevance and in weighing the prejudicial effect of proffered evidence against its probative value. Its rulings will not be overturned on appeal absent an abuse of that discretion. A trial court abuses its discretion when its decision exceeds the bounds of reason or is arbitrary, capricious, patently absurd, or even whimsical. Put another way, a ruling that constitutes an abuse of discretion has been described as one that is so irrational or arbitrary that no reasonable person could agree with it. People versus Lamb. Under abuse of discretion standard, appellate court will not disturb the trial court's ruling unless it was arbitrary, capricious, or made in patently absurd manner that resulted in a manifest miscarriage of justice. Peterson contends the prosecutor's questions to Pete regarding how she felt about coming into court today was improper, and the trial court permitting it was inexplicable. Peterson is mistaken. The court instructed the jury, as courts do in every criminal trial, on non-exclusive lists of 11 factors jurors may consider in judging the credibility or believability of the witness. Cal Crim number 226. One of those factors is, what was the witness' attitude about the case or about testifying? Other factors include, did the witness make a statement in the past that is consistent or inconsistent with his or her testimony? And did the witness admit to being untruthful? Pete's credibility was a key issue in the case indeed. In cross-examination, Pete's counsel repeatedly asked Pete to admit she lied. Peterson also asserts this testimony was irrelevant and prejudicial because it elicited sympathy from the victim. However, at the outset of the trial, the court instructed the jury, your verdict must be based only on the evidence presented during trial in the court and the law as I provided to you. The court also told the jury, do not let bias, sympathy, prejudice, or public opinion influence your decision. And before closing arguments, the court again instructed the jurors, you must not let bias, sympathy, prejudice, or public opinion influence your assessment of the evidence or your decision. We presume that the jury understood and followed the court's instructions in reaching its verdict. People versus Love, 2005. Evidence Code Section 352.2 does not apply retroactively, and the trial court did not abuse its discretion in admitting a photograph of Peterson's torso and arms. Oh, that's fascinating. Peterson contends the trial court reversibly erred in admitting the evidence of Peterson's creative expression, specifically a photograph that showed tattoos on his torso and arms. At trial, Officer Sandra Cabral testified she and Pete's testimony about being hated. Oh, it has to be something else. Okay. She and her partner stopped a vehicle that matched the description of a vehicle in a radio call they received. 4 people, later identified as Peterson, Pete, Harrison Smith, were in the vehicle. An ambulance took Pete away, and Cabral and her partner arrested the other 3 and took them to Hollywood Station for further questioning. As the officer had found in the vehicle, a handgun was warm to the touch and the slide lock position. When they got to the station and tested Peterson, Harrison Smith for gunshot residue, the prosecutors marked as exhibits 3 photographs taken at the station that depicted Peterson, Harris, and Smith, respectively. In a photo marked as Exhibit 18, Peterson appears to be wearing black shorts or swim trunks. He is shirtless and tattoos on his chest and arms are visible. In a photo marked as Exhibit 19, Harris appears to be wearing a black 2-piece swimsuit, tattoos are visible on her arms and left thigh, and a photo marked as Exhibit 20. Smith appears to be wearing black pants, a long sleeve black top. At sidebar, Peterson's counsel objected to the photograph, arguing it was irrelevant and only swayed the jury because it looks like he got tattoos. The court replied the photos were to show who the people are she was referring to, Officer Cabral. To the swabs from, the court continued, I don't see anything wrong. He has no shirt on. He has tattoos. Other than that, what's wrong with the picture? At the conclusion of the evidence, the court discussed the exhibits with counsel. When the court asked the defense counsel if he had any objection to the admission into evidence of exhibits 18, 19, or 20, he replied, no, Your Honor. In support of his claim of reversible error, Peterson cites Evidence Code Section 352.2, Assembly Bill. We ain't doing all that stuff, man. The statute requires trial courts to consider certain factors when a party seeks to admit as evidence a form of creative expression in any criminal proceedings. Evidence Code 352.2 sub. A statute defines creative expression as the expression or application of creativity or imagination in the production or arrangement of forms, sounds, words, movements, or symbols, including but not limited to music, dance, performative art, visual art, poetry, literature, film, and other such objects or media. Peterson cites People versus Venable. In Venable, the Court of Appeal held Evidence Code Section 352.2 applies retroactively to cases that are not final. In his opening brief, Peterson failed to note that our Supreme Court had granted review in Venable. Some 9 months later, Peterson also failed to cite either of the 2 cases that reached the opposite conclusion, People versus Sladden. November 15, 2023, Ramos Supra. Review granted July 12, 2023. In his reply brief, Peterson acknowledged the grant of review and mentioned Sladden. Peterson stated that he relied on his previous argument pending a final outcome in the High Court on August 28, 2025. Our Supreme Court held in Aguirre Supra that Evidence Code Section 352.2 does not apply retroactively. Aguirre involved in handwritten rap lyrics and instant messages attributed to defendant. Chief Justice Guerrero explained that the High Court, having examined the language of Evidence Code Section 352.2 and its uncodified legislative findings, saw nothing that clearly and unavoidably citation reveals an intent to depart from the general rule of prospective-only application. Accordingly, Evidence Code Section 352.2 does not assist Peterson. In any event, the record does not support Peterson's contention that Exhibit 18 injected racial bias into the proceedings. The prosecution did not offer the photograph as evidence of any alleged gang affiliation. There was no gang affiliation in this case, and no one ever suggested that Peterson had any gang ties. So basically they're saying, bro, you just brought in some shit that didn't even make sense. But you got to swing for the fences because you'll never land in the hills. The prosecution offered Exhibit 18 and Exhibits 19 and 20, and the court admitted them into evidence solely to show the identity of the individuals officers swabbed for gunshot residue at the police station. The record does not reflect whether Peterson was wearing a shirt when police stopped his vehicle. Pete testified they just emerged from the swimming pool. She was wearing a bikini and Harris was in a swimsuit too. Pete's stylist, Eric Clubberson, called by defense, also testified both Pete and Harris were wearing swimsuits when they got into the SUV. Culberson also testified Peterson was wearing drawers when they left Jenner's house. In his closing argument, Peterson's counsel referred to what Peterson was wearing as his trunks. There was no testimony at trial that Peterson had been wearing a shirt, and the officers asked him to remove it in order to swab his hands for gunshot residue or take his photograph. That's like lie number 7. Peterson asserts the prosecution explicitly and improperly introduced racial bias into the proceedings by asking a witness about what appears to be a tattoo on the firearm in the middle of Peterson's chest. Defense witness Clubberson testified he was Pete's stylist and friend. He sometimes was Pete's driver as well. From the questioning, it appears the defense called Clubberson to ask him if Pete or Harris had a gun in their luggage. On direct examination, defense counsel also asked Clubberson if he'd ever seen Tory with a gun. Clubberson replied, no. Counsel asked if Peterson ran around with guns. Clubberson replied, no. On cross-examination, the prosecutor asked Clubberson a series of questions about whether he'd ever seen Harris with a gun or whether he'd ever seen Pete with a gun. At any time that day or night, he did not ask Clubberson if he had ever seen Peterson with a gun. On redirect, defense counsel then asked Clubberson if he'd ever seen Peterson with a gun, if he'd ever seen Peterson have a bag that has some weapons with him, and whether he'd ever seen Peterson discuss anything about firearms. Clubberson answered no to those questions. On re-cross-examination, the prosecutor and Clubberson had the following exchange. Question. Now, counsel asked if you ever seen Tory talk about guns or if you ever seen him with guns. Do you recall that? Answer. Yes. Question. Do you see the big gun that Tory has tattooed on the center of his chest? Answer. No. I haven't seen Tory's body. Defense counsel did not object to that question. In short, the record does not support Peterson's contention that prosecutors utilize Peterson's tattoos, which is intertwined with his rapper persona, to lead jurors. To conclude, he is a violent criminal with a predisposition to commit crimes. It was defense counsel who asked on both direct and redirect if Clubberson ever had seen Peterson with a gun. Neither of the prosecutors even mentioned Peterson's tattoos, much less the tattoo of a firearm in their closing arguments. Peterson also complains that Pete's testimony about a music video Peterson had released poisoned the proceedings by directing the jury to infer that if Peterson was chopping up a horse legs in a music video, he was violent enough to shoot her. Peterson seems to be referring to Pete's answer to a prosecutor's question about whether she regretted having come forward. If I would have known that coming out and speaking my truth would come with people agreeing with me being shot, if I would have known, if I would have started to lose my confidence, I would have started to lose my confidence, lose my friends, lose myself. I didn't ask for this. I didn't want to come out about it in the first place. I started to feel like, damn, maybe I should be dead. I got to watch Tory drop music videos chopping up horse legs and people laughing at it. Like, that's okay. Defense counsel did not move to strike Pete's reference to the music video. No such music video was offered into evidence or shown to the jury. So he just lied right there. There's no goddamn horse video. In any event, Pete's brief reference to the video, which she took as directed at her own or even as a threat, was permissible for the same reasons we've already discussed. It's relevant to Pete's attitude about the case or about testifying. The trial court did not impermissibly chill Peterson's right to testify, and as Peterson did not testify, he cannot raise this issue on appeal. Peterson asserts the jury did not hear Peterson's account regarding the night in question because the court ruled that if he testified, prosecutors could introduce his music video and rap lyrics during cross-examination. Peterson mischaracterizes the record. Midway through the defense's case, the prosecutor told the court he was asking to inquire about prior acts of violence. If Peterson testified to rebut the character evidence put on by the defense, the court replied, well, I think the state of the evidence as it is now, I would not allow that. Of course, I don't know what he would say if he testifies. It may become relevant depending on what he were to say. But at this point, I will exclude that. So you just lied again. And y'all be cool with this shit, bro. The prosecutor listed a number of items with which he proposed to impeach Peterson, including social media posts. And if anybody want to get in the comments and argue, you don't know you in there, but they have a whole stenographer there. That's why they tell the other people, shut up. She's writing down everything, or he's writing down everything. Even though I've never seen a male stenographer. The prosecutor listed a number of items in which he proposed to impeach Peterson, including social media posts, rap lyrics, Instagram posts, a 2019 incident and 2020 incident with August Alsina, an incident with Love and Hip Hop star Prince at Florida nightclub, and more. The court stated some of this would be admissible. Those portions that pertain to this case, some wouldn't. The court continued, the best I can tell you at this point is if your client testifies, I have to take it on a case-by-case basis. But essentially, anything pertaining to this case obviously is fair game. If it pertains to some other incident, maybe it is, maybe it isn't. It depends. After the defense had called 7 witnesses, the following exchange took place. The court. So, Mr. I don't know how to say Kel's name. Magnuson, you have advised me that your client has elected not to testify. Mr. Magnuson. That's correct, Your Honor. The court. So, Mr. Peterson, you know you have the absolute right to testify if you choose. You have the absolute right not to testify if that's your decision. If you testify, you will take the stand and be questioned just like all the other witnesses were by both sides. If you choose not to testify, I will instruct the jury not to consider it or not to hold it against you. Do you understand what I've told you so far? Mr. Peterson. Yes, Your Honor. The court. Have you had a chance to discuss that decision with your attorney? Mr. Peterson. I have, Your Honor. Do you understand what I've told you so far? Mr. Peterson. Yes, Your Honor. The court. Have you had a chance to discuss that decision with your attorney? Mr. Peterson. I have, Your Honor. The court. And based on your decision, it is your choice at this point not to testify. Mr. Peterson. I will not testify. Neither Peterson nor his counsel ever told the court that Peterson wished to testify, but was deterred by the prospect of impeachment by the prosecution. In Luce versus United States, the Supreme Court considered a case like this one in which a defendant did not testify and then argued on appeal. The court had abused its discretion in denying the motion in limine to preclude the prosecution from asking about a prior conviction. The court stated, a reviewing court is handicapped in any effort to determine if a trial court performed the necessary balancing because to conduct that review, the court must know the precise nature of the defendant's testimony, which is unknowable when, as here, the defendant does not. Meaning, how the hell you gonna say some shit you didn't say and you had the opportunity to say that shit? Shut the hell up. And Luce is here. There was no commitment by the defendant that he would testify if his request to exclude possible impeachment were granted, nor did he proffer to the court as to what his testimony would be. Moreover, a review court cannot assume that the adverse ruling motivated a defendant's decision not to testify. Luce Supra 469 U.S. at P42. And even if these difficulties could be surmounted, the reviewing court would still face the question of harmless error. The Supreme Court concluded the careful weighing of probative value and prejudicial effect required of a trial court can only be evaluated adequately on appeal in a specific factual context of a trial as it has unfolded. Brennan J. Also see People versus Collin, adopting Luce rule. People versus Duan. It is well established that the denial of a motion to exclude impeachment evidence is not reviewable on appeal if the defendant subsequently declines to testify. The Luce court's reasoning is directly on point here. Peterson argues Luce does not apply because that case involved possible impeachment with a prior criminal conviction. And 2, Evidence Code Section 352.2 would have required the court to exclude all of the possible impeachment evidence. We are not persuaded. I'm sorry, y'all. Nothing in Luce suggests nothing in Luce suggests its holding is limited to impeachment with a prior conviction as opposed to other types of conduct or acts. And as we have said, Evidence Code Section 352.2 does not guide us in this appeal. Aguirre Supra, 18 Cal 5th at P693. The mention of Peterson's criminal case in Florida was not prejudicial. Wow, who would have known? Peterson asserts inculpatory statements, which were inculpatory as to the shooter's identity, were improperly introduced in spite of their factual falsity. Peterson apparently is referring to Pete's testimony that shortly after the shooting, when she and others heard police sirens and Peterson offered her and Harris $1 million, Peterson said, I can't go to jail. Already got caught with a gun before. Don't tell on me. A few questions later, the prosecutor asked Pete, what's he saying exactly? Pete replied, I'll give y'all $1 million if you don't say anything. I can't go to jail no more. I'm already on probation. In the defense case, Peterson's counsel recalled the lead detective, Ryan Strogner. Counsel questioned Strogner about his interview with Pete after the shooting. Counsel asked if Pete had told him that Peterson stated, Please don't say anything because I'm on probation. Stroder began to answer. It was something that, when the prosecutor objected, the court overruled the objection. The exchange followed. Question. Sir, did you do any investigation afterwards to find if my client was on probation at the time of this case was happening in July 2020? Answer. Yes. Question. Was my client on probation, sir? Answer. No. Not to my best recollection. So that actually helps you out, dumbass. After the defense counsel asked Strogner about probation, the prosecutor began to ask a question about it. Defense counsel objected. At sidebar, the prosecutor told the court Mr. Lanez was actually on a Florida-Miami probationary term that started in 2017. She added that even if that were not the case, defense counsel was accusing the victim of lying about what Peterson had said. Defense counsel stated Peterson got arrested in Miami case, but was never charged. Outside the juror's presence, the court and counsel discussed the matter at some length. The prosecutor told the court the defendant was ordered diversion, sick for a gun, possession in 2017. He released an Instagram video where he talks about going to his probation officer. After more discussion, the court stated, I will allow you to inquire that there was an incident in 2017. He was placed on court diversion. Don't mention what the arrest was for. And we'll leave it at that. Later, defense counsel and prosecutor stipulated to advise the jury that Peterson was ordered a granted diversion for a criminal case in 2017, and that diversion was terminated in April of 2017. The court told the jury stipulation meant that is a fact that's not in dispute in the case, and they were to accept that as conclusively proven. Both counsel agreed to special jury instruction about diversion. In accordance with that agreement, the court instructed the jury about the nature of diversion. The instructor stated, diversion and probation were not the same thing. You are not to speculate about circumstances of Mr. Peterson's granted diversion in 2017. Well, then why the hell would y'all even bring it up, though? But then again, they said, oh, because he said he was on probation. So never mind. Hold on. I damn near turned into one of y'all. It was terminated in 2017. And you are not to conclude from this evidence that Mr. Peterson has a bad character or that he is disposed to commit. Thus, after the prosecution asked Pete about Peterson's statements, defense counsel raised the issue of probation with the detective in an effort to show Pete lied to the police. Pete's testimony that Peterson said he'd been caught with a gun before was not false. In any event, Peterson's counsel reached an agreement with the prosecution to present a stipulation with true facts to the jury and for the court to instruct the jury on what diversion means. The record does not support Peterson's claim of error in this point. If anything, it actually helped him because basically the damn judge allowed them to say, well, he wasn't on probation, which actually helps the defense, dumbass. The trial court did not err in permitting the prosecution to play for the jury as a prior inconsistent statement. The recording of Kelsey Harris' interview with prosecutors. Peterson contends to the trial court reversibly erred in permitting the prosecution to play for the jury its recorded interview with Kelsey Harris. Peterson relies on the confrontation clause in Crawford v. Washington 2004, 541 U.S. 36. Peterson is mistaken. The issue of admissibility under evidence code. It does not involve the confrontation clause. The prosecution subpoenaed Harris to testify at trial. The court had appointed counsel for Harris, and the prosecution had granted her use immunity. Once on the stand, to say Harris was a reluctant witness is an understatement. Harris repeatedly claimed not to remember what had happened that early morning and in the days following the shooting. To answer the question after question, Harris replied she didn't remember, couldn't remember, or didn't know. She repeatedly said it was a blur. Several times. Harris said she wanted to take the fifth. The court told her she had to answer the questions. So when y'all say this shit, when y'all say, and it's all you dumbasses who are Tory Lanez supporters, not the smart Tory Lanez supporters, the dumbass ones. This is the same shit from the YSL trial. Remember when Woody ass took the fifth and they threw his ass in jail? And then he had forced immunity? This is what the hell happened. You guys are welcome. Harris repeatedly said, I don't want to be here. In an attempt to refresh Harris's recollection, the prosecutor played excerpts of a recording of a September 14, 2022 interview. The two prosecutors had interviewed Harris in the presence of her husband and an investigator from the district attorney's office. Two attorneys representing Harris were present on the phone. Again and again at trial, Harris told prosecutors she had to refresh her recollection with a recording, confronted with her prior inconsistent statements. Harris testified that there were some things she just wasn't being truthful about in her interview. Harris also testified she didn't remember telling prosecutors things that she can be heard saying in the recording. When asked if she had said in an interview that she'd seen Peterson shooting through the window to the top of the door, Harris replied, again, this is the night of alcohol. I don't. You know. I don't know. I don't know. So she was in there keeping it G. In light of Harris's claimed failure to recall what she told the authorities and her testimony that she had been untruthful in some of her statements, the prosecution proposed to play the recorded interview for the jury, citing evidence code section 770 and 1235. The court said it would allow that section 770 generally governs the admissibility of extrinsic evidence of the witness' prior inconsistent statement for impeachment. The statute requires only that the witness be given an opportunity at some point in the trial to explain or deny the inconsistent statement. Evidence code 770 sub A. Section 1235 provides evidence of a statement made by a witness is not made inadmissible by the hearsay rule if the statement is inconsistent with his testimony at the hearing and is offered in compliance with section 770, where the out-of-court statement is inconsistent with the witness's trial testimony. The jury may consider the prior statement for its truth as well as for the light it sheds on the witness's lack of credibility. See Cal Crim number 318. Jurors may use witnesses' prior statement to evaluate witnesses' testimony and as evidence that information in earlier statement is true. So the prior statement has a dual purpose. It may be considered for impeachment as well as substantive evidence when a trial court concludes on substantial evidence that a witness proffered professed lapses of memory are false, evasive devices are avoidable truthful answers. It may admit it as inconsistent. The witness's prior statements describing events the witness now claims to have forgotten. People versus Arias. The trial court did not abuse its discretion in admitting evidence regarding an Instagram post. Peterson contends the trial court reversibly erred in admitting an allegedly inculpatory Instagram post, which was disclosed to the defense in an untimely fashion, amounted to inadmissible hearsay, and was highly prejudicial, thereby resulting in a manifest injustice. We do not agree. After the jurors were selected on a Thursday, the court excused them so it could discuss various issues with counsel before opening statements set to begin on Monday. During that discussion, the prosecutors told the trial court and defense counsel that they'd just been made aware of a September 2020 Instagram post by the defendant, in which he said a comment posted by someone else that Harris shot Pete was not true. Wow. The prosecutor gave that information on a CD to defense counsel, who said he'd look at it, but he thought there might be a foundation issue. The following Tuesday, the prosecution filed a motion to admit the defendant's statement on Instagram. The prosecution attached to its motion of a photograph of a post by Lil Drew Made the Beat that said, "This goofy ass nigga said he ain't shoot her. They literally have matched bullets from his gun to the ones in her foot." Below is a statement like by Frosted Cupcake Addict at 281-393 others. Next by the Shade Room. Megan Thee Stallion's producer alleges that authorities have matched the bullets from Tory Lanez guns to the ones found in her foot. See earlier posts. Under that, view all 13,727 comments. Next, Spliff K says, "People saying Kelsey shot her. Crying emoji. Finally, a post by Tory Lanez. Spliff K. That's not true." The date on this post is September 25th, 2022. Now, let me ask y'all this question before we finish up. Do you think this motherfucker just liked her damn post because it said that she wasn't the shooter, or because he didn't want to piss her off and letting her know the truth? I'm probably going to go with the second thing. 2 days later, the court discussed the Instagram post with counsel, citing People versus Valdez. The court stated if the people established the requisite foundation, namely that account is linked to a certain individual, that goes more to the weight of the evidence than the admissibility. Detective Warren Ebenhart then testified. Ebenhart stated that he had clicked on the Tory Lanez hyperlink and that directed him to an Instagram page where the username was Tory Lanez. Ebenhart explained that blue check on the page was essentially a verification badge. Ebenhart testified that Tory Lanez's account has 11.8 followers. He noted photographs on the account appeared to depict Peterson. On cross-examination, when asked, do public figures have people who run their Instagrams? Ebenhart replied, that's fair to say, yes. Ebenhart testified he never said Peterson made the post. Added he can only testify to the username of the account that the post came from. Ebenhart stated that he did not know who was controlling Peterson's account. Defense counsel marked as Exhibit E and showed Ebenhart an Instagram post apparently from user Mid Jordan replying to Messiah Carey. The post states, "This is not real. Y'all want to believe anything. I am the only person with access to Tory's account at the moment." Defense counsel noted that the post had been liked by Tory Lanez. Ebenhart testified that he'd never seen the post. When the time came to discuss with the counsel the admission of the exhibits, defense counsel said he objected to Exhibit 40A, the Instagram post, and Exhibit 40B, photographs on the account. on foundation. The court admitted the exhibits over counsel's objection. Defense counsel moved the admission of Exhibit E. The court stated it wasn't sure any foundation was laid. The prosecution objected that on the ground that the court sustained the objection. The court noted the exhibit's exclusion did not preclude defense counsel from arguing that any post would have come from other people other than Peterson, and counsel did so. On appeal, Peterson complains of late discovery. Counsel never made this objection during trial. He did not ask for a continuance, exclusion of the exhibit as a discovery sanction, or a jury instruction. It was not until Peterson filed his motion for a new trial that he first raised the issue. Peterson had forfeited the timeless issue on appeal, meaning if you was going to bitch about it, why didn't you do this during trial? Why wait until we get here now? Because you're lying. Peterson also asserts the Instagram posts are inadmissible hearsay. A trial court's ruling on the admissibility of evidence, including on hearsay nature of the evidence in question, is reviewed for abuse of its discretion. We need not reach the question of any abuse of discretion here, and we see none in any event because Peterson did not object to the exhibit's admission on this ground at trial. He raised it for the first time in his new trial motion. Peterson's failure to object to the post as hearsay at trial also forfeits that argument on Appeal Evidence Code 353, sub C People versus Dimitri Leas. Judgment may be reversed because of erroneous admission of evidence only if an objection to the evidence was timely made and so stated as to make clear the specific ground of the objection. Finally, in any error admitting the Instagram post was harmless, as the trial court noted, the Instagram post was an extremely minor issue in this case. The case turned on Pete's testimony, Peterson's admission to Harris when he called her from jail, and other similar evidence. Detective Eberhard testified he was not saying that Peterson had posted the statement. That's not true. And he admitted he had no knowledge of who controlled Peterson's Instagram account. The trial court properly instructed the jury on count 1 and a firearm enhancement. Any error in the instructions on count 2 was harmless. Oh, this might be a problem. I might be on the Tory Lanez side depending on how this shit go, because I don't like the way that sounds. Peterson contends the trial court reversibly erred in its instructions to the jury on counts 1 and 2. Count 1 alleged assault with a semi-automatic firearm in violation of section 245, subdivision B, and count 2 alleged having a concealed unregistered firearm in a vehicle in violation of section 25400, subdivision A1. And count 1, the people allege Peterson personally used a firearm in the commission of the offense. Within the meaning of section 12022.5, subdivisions A and D, at the conference on jury instructions, the trial court told counsel it would give Cal Crim, Union Act, and intent, general intent. The court continued. So all 3 crimes here are general intent crimes. Defense counsel did not disagree or object. Peterson's argument on appeal is somewhat difficult to understand. He asserts the assault with the semi-automatic firearm is a general intent crime. Yet, the enhancement attached to this count through Penal Code section 12022.5 requires specific intent. Peterson does not cite any case in support of this contention. No case has held the assault with a semi-automatic firearm or a personal use of a firearm enhancement requires specific intent. To prove assault with a firearm, the prosecution must prove 1, the defendant didn't act with a firearm that is by its nature would directly and probably result in the application of force to a person. 2, the defendant did not act willfully. When the defendant acted, he was aware of facts that would lead a reasonable person to realize that his act is that his act by its nature would directly and probably result in the application of force to someone. Meaning, nigga, if you shoot the gun, you know exactly what the hell gonna happen. Bang, bang, boom, boom, injure, injure. And 4, when the defendant acted, he had the present ability to apply force with a firearm to a person. Thus, this instruction requires a defendant to have acted willfully and with awareness of facts that a reasonable person will recognize will result in the application of force to a person. The jury instruction defines willfully. Someone commits an act willfully when he does it willingly or on purpose, as opposed, for example, to accidentally. The word willfully implies simply a purpose or willingness to commit the act. It does not require any intent to violate law, to injure another, or to acquire any advantage. Quote and pen. The word willfully, when applied to the intent with which is an act done, when the act is done, implies simply a purpose or willingness to commit the act. Willfully implies that the person knows what he is doing, intends to do what he is doing, and is a free agent. Similarly, The jury instruction for the personal firearm use enhancement requires only that the defendant personally use a firearm during the commission of the offense. Peterson's contention regarding that count 2 requires more discussion. Peterson asserts, likewise, count 2 is a specific intent crime and required instruction with Cal Crim number 252. That instruction is entitled Union of Act and Intent General and Specific Intent Together. To prove the offense of carrying a concealed firearm within a vehicle, prosecution must prove 1. Defendant carried within a vehicle a firearm capable of being concealed on the person. 2. The defendant knew the firearm was in the vehicle. 3. The firearm was substantially concealed within the vehicle. And 4. The vehicle was under the defendant's control or direction. Knowledge is not the same thing as specific intent. Knowingly merely requires proof of knowledge of facts that constitute the offense. People, Calban, 1976-65, Cal Lab 3D 578-584. A requirement of knowledge is not a requirement that the act be done with any intent. With any specific intent. Citations. The word knowing was used in a criminal statute imports only an awareness of the facts which bring the prescribed act within the terms of the statute. However, knowledge is required as a requirement of state for a violation of the statute. For the first time in his reply brief, Peterson cites the bench note to Cal Crim number 250. The note states, this instruction must not be used if the crime requires a specific mental state, such as knowledge. Even if the crime is classified as a general intent offense, the case involves both offenses requiring a specific intent or mental state and offenses that do not. The court may give Cal Crim number 252. Union of act and intent, general and specific intent together. In place of this instruction, we review the adequacy of an instruction independently. From the bench note at Cal Crim number 250, it appears the trial court should have given the jury Cal Crim number 252, listing assault with a semi-automatic firearm and a firearm enhancement, as well as count 3, discharge a firearm with gross negligence, as requiring only general criminal intent, but listing carrying a concealed firearm within a vehicle as requiring the specific mental state of knowledge. However, on this record, the court's failure to do so was harmless. Nah, bruh. Nah. You can't say that. You can't say, oh, nah. Well, if he carried the gun right here, that still means that he's crazy as shit opposed to him having it on him. Nah, that's not the same. Hell nah. No. That's for you guys to be perfect. That's bullshit. However, on this record, the court's failure to do so was harmless in reviewing a claim of instructional error. The court must consider whether there is a reasonable likelihood that the trial court's instruction causes the jury to misapply the law in violation of the Constitution. Yeah, I would. If you're trying to hide somewhere, if you have it on you, I would think 2 different things. What the hell are you talking about? Either you bold as hell or you trying to be slick. It's one of the two. So, y'all bullshitting right there. We reviewed the challenge instruction in the context of the instructions as a whole and the trial court record to determine whether there is a reasonable likelihood the jury applied the instruction in an impermissible manner. Instructional error requires reversal of the judgment only if it resulted in a miscarriage of justice, meaning it is reasonably probable the defendant would have fared better in the absence of the error. People versus Watson. The trial court did instruct the jury that the prosecution was required to prove not only that Peterson committed the prohibited act, but that he did so with wrongful intent and that he knew the firearm was in the vehicle. In closing, the prosecutor argued Peterson knew it. The gun was there. Of course he did. He grabbed it. He shot Megan with it. The defense counsel told the jurors, my client didn't even know the gun was there. Counsel said Peterson jumps in the seat after the girls are in the car. Counsel continued. They're trying to say my client knows the gun was there and he touched the gun and he put the gun there. Why? Then, counsel asked with his DNA not found on the gun. In short, the jurors were all aware that the prosecution had to prove Peterson knew the gun was in the vehicle. Jurors are presumed to be intelligent and capable of understanding and applying the court's instructions. Reversal on count 2 is not required. Any ambiguity, I can't even say this shit right. We're just gonna skip on. It's harmless in this case. On the allegations that in committing the offenses in counts 1 and 3, Peterson personally inflicted great bodily injury on Pete, the trial court instructed the jury with Cal Crib number 3160. The instruction states great bodily injury means significant or substantial physical injury. It is an injury that is greater than minor or moderate harm. Peterson cites a bench note following the instruction that cautions courts. This sentence of the great bodily injury definition could result in error if the prosecution improperly argues great bodily injury may be shown by greater than minor injury alone. Cal Crim number 3160 bench notes. The note cites People versus Medellin. Definition reasonably susceptible to prosecutors' erroneous argument that the jury need only be greater than minor. In People versus Quinones, 46 Cal App 5th, 467-466, uphold an instruction containing great bodily injury definition as written. Any ambiguity, there we go, I said it right. Any ambiguity in this definition is harmless in this case because substantial evidence established beyond a reasonable doubt that the injuries Peterson inflicted on Pete were more than moderate harm. Indeed, they are more properly characterized as significant or substantial harm. Pete had surgery to remove bullet fragments in both her feet. She had a lot of pain and couldn't walk for a while. Pete had physical therapy for a few months. The orthopedic surgeon who operated on Pete's feet testified at trial, and the jury saw x-rays and a report of the operation. The surgeon told the jury Pete was placed under general anesthesia for the surgery. The surgeon described in detail the steps a team of 3 surgeons took to remove questionable tissue and the metal fragments, flush the areas, and close the wounds with sutures. Pete was admitted to the hospital after the surgery. The testimony was more than sufficient to support the jury's finding that Peterson personally inflicted great bodily harm injury on Pete. Section 12022.7 does not require a victim to have suffered permanent, prolonged, and protracted disfigurement, impairment, or loss of bodily function, abrasions in bruises to victim's legs, knees and elbows, neck injury, and soreness in vaginal area that significantly impaired victim's ability to walk were sufficient. Victim was shot in leg. Some bullet fragments lodged in victim's arms. Little blood loss. No sutures used. Victim treated at hospital, then released and went to work the next day. The prosecutor's statements in closing argument do not require reversal. Peterson contends the prosecution engaged in prosecutorial misconduct and making improper comments during closing argument. According to Peterson, these improper comments consisted of improper appeals to emotion and sympathy for the victim, arguing facts not in evidence, and then, I don't know what the hell, denigrating defense counsel. For real? I gotta hear this shit. Peterson implicitly acknowledged trial counsel did not object to any of the statements of which Peterson now complains. But that's why he was bitching about ineffective counsel. So y'all kind of got to play that one right there. The general rule is that a defendant may not complain on appeal of prosecutorial misconduct unless in a timely fashion and on the same ground. The defendant made an assignment of misconduct and requested that the jury be admonished to disregard the impropriety. Peterson cites a case for the proposition that this forfeiture rule does not apply if an admonition would not have cured the harm, but he does not explain how admonitions here would not have cured any harm from the prosecutor's statements, meaning you hear a bell rung, you're not going to forget that it was wrong. But they said, but we never complained about a bell being rung in the first place. In any event, Peterson claims the prosecutorial misconduct fails on the merits. The prosecutor's conduct violates the 14th Amendment to the federal Constitution when it infects the trial with such unfairness as to make the conviction a denial of due process. Quoting People versus Morales, in other words, the misconduct or error must be of significance to result in the denial of the defendant's right to a fair trial, even if the misconduct is not so egregious as to render the trial fundamentally unfair. Reversal is required if the prosecutor used deceptive or reprehensible methods to attempt to persuade either the court or the jury that are reasonably likely to have affected the outcome of the proceeding. Choice at PP 114 through 115, quoting People versus Cash 2002. We might need to look into that. That sounds crazy as hell. As we have explained, the prosecution's questioning of Pete about why she initially lied to medical personnel and police, the criticism directed at her after she accused Peterson, and her attitude about the case and about testifying was not improper. Reference to that testimony in closing argument was not improper for the same reason, meaning y'all can't bitch about this if y'all brought it up too. As for the prosecutor's reference in his opening statement to what he expected Justin Edison to say if he testified, it is not uncommon for counsel on both sides to tell the jury that a particular witness will testify only to be unable ultimately to procure that witness's appearance with respect to the prosecutor's suggestion that Peterson tried to bribe Harris in his question, where is Justin right? Pete testified, Peterson said, don't tell on me and I'll give y'all $1 million if you don't tell on me immediately after the shooting. Harris said the same thing in her September 2022 interview with prosecutors, though by the time of the trial 3 months later, she equivocated about why Peterson offered her the money. Harris also told prosecutors she met with Peterson outside a hotel a day or two after the shooting, and he asked her if she needed a job, if she wanted to work with him. He also mentioned investing into a business. Prosecutors may argue inferences from the evidence. Prosecutors are granted wide latitude during arguments. When attacking the prosecutor's remarks to the jury, the defendant must show that in the context of the whole argument and the instructions, that was a reasonable likelihood the jury understood or applied the complaint of comments in an improper or erroneous manner. Yeah, but that's bullshit because they should have never brought up somebody who didn't testify. Yeah, that's kind of lame though. Y'all can't say that shit because now you are that is true. So I disagree with this one wholeheartedly. Peterson has not made that showing here. Finally, regarding Peterson's assertion that prosecutors denigrated defense counsel repeatedly throughout closing argument, this trial was vigorously litigated and hard fought. Both sides accused the other of misleading the jury. Defense counsel told the jury the prosecution's case was full of holes, and the prosecutors had the audacity to ask the jurors to speculate. Counsel asked why the prosecution hadn't called Sean Kelly as a witness or the investigating officer, Detective Strogner. Counsel queried why the prosecutor had objected to Kelly's testimony because they didn't want you to know the truth. Counsel asked, "Where's Joaquin Smith? Why didn't they call him?" Referring to himself, defense counsel asked the jury, "Who told you the truth from the first day? When I got up here and gave any opening statement," counsel said, "From the opening statement, we had a lengthy discussion when I was informed of this over lunch with my client, my associate, and my investigator. We came to the conclusion that we're not going to call him because obviously his testimony is going to be putting a gun in the hands of Kelsey. And that's what he told us all when we just did an interview upstairs. At this point, my position was the juries believe our theory. I think Sean Kelly already put the gun in Kelsey's hand. And if they're going to believe that he took the gun from him and you started to shoot it yourself, to me, it's kind of an absurd argument. Adding another person to say who has some connections to you as a security or a friend isn't going to do anything. So we decided we're not going to call him till this morning. I told the prosecution we won't call him. I'll just move forward into the argument. I'm ready. They're ready. Let's just argue and instruct and be done with this." Defense counsel explained further, and the reason for that, Your Honor, is obviously with the holidays coming, my fear is I'll lose this witness. The witness made it very clear he's not going to stay here. Secondly, and more importantly, I think we'll have a mistrial and we're going to lose jurors. The court asks, "And you talk to your client, or do you need to speak further to him?" Counsel replied, "I spoke to my client. If the trial continues another 7 days, we'll have a mistrial. My client definitely doesn't want that. My client wants closure on this. He has family flying back out to Canada, and he wants to finish this, only to be found guilty." So everyone's evidence they've introduced. Ladies and gentlemen, they try to mislead you. In sum, none of the prosecutor's statements constituted deceptive or reprehensible methods that were reasonably likely to have affected the outcome of the proceeding. The record does not support Peterson's contention that prosecutorial misconduct interfered with his right to conflict-free counsel. Peterson retained Sean Chapman Holly to represent him in this case. Holly represented Peterson through the preliminary hearings as well as the extensive pretrial proceedings. According to Holly, with the trial expected to begin in late November and December of 2022, Peterson wanted to add another lawyer to the team, George Madison. In a September 6, 2020 email, Holly explained to Brian Gott, who appears to have been Peterson's business manager, Tory has known him for a long time and trusts him. Holly was engaged in arbitration out of state that began in May 2020. It did not conclude until December 16, 2022, nearly 2 weeks after trial commenced. In a letter dated January 10, 2023, to the trial court, Holly referred to this other engagement and explained, "Mr. Peterson understood and agreed that George Magnuson would represent him at trial and that I would not." An email Peterson attached to one of his pleadings in connection with his motion for a new trial reflects a second reason Holly did not represent Peterson at trial. In an email dated November 21st, 2022, Peterson, with a copy to Magnuson, Holly stated she was not comfortable advancing a defense theory that it was Kelsey Harris and not Peterson who shot Pete. So all this shit about Tory Lanez trying to protect a black woman is bullshit, because you heard his goddamn lawyer bring this shit up, and you heard his second lawyer say, "I'm not with this damn theory of your ass lying on her because you full of shit." In Holly's view, it was not a viable strategy. Once again, you're not shit. You're full of shit. Holly recommended that Peterson discuss with Magnuson's willingness and ability to move forward with that defense. The record, again, an email Peterson filed in the trial court reflects a third issue. On December 18, 2020, 2. Holly emailed Peterson and let him know she was going to file a motion to withdraw as one of his attorneys of record. Holly stated evidence had been elicited during Harris's testimony that Holly was somehow involved in facilitating an arrangement between Peterson and Harris, whereby Peterson would finance Harris's business or something like that, and in order to curry favor with her, thereby aligning your and her interests as far as the case was concerned. Holly continued, "You and I both know that this never happened." Holly added she did not know whether Peterson actually made such a statement to Harris or whether Harris made this up herself. Holly stated, "All I do know is that this did not happen, nor would it ever happen." Holly explained, "In any event, the fact that these false allegations have been made about me and that they are now evidence in the case makes it a conflict as an ethical and legal matter. For me to continue to represent you, and as a result, I am obligated to withdraw as your attorney." Without any citation to the record, Peterson asserts, despite prosecutors' plain acknowledgement that Holly was not involved in the alleged bribery of Harris months earlier, prosecutors opted to wait until mid-trial to raise the exact same allegations, relying on nothing more than Harris's name, inconsistent with statements dating back to September 2020. Peterson claims these allegations left Holly with no choice but to disengage fully lest her presence harm her client. Peterson's wholesome failure to support any of these assertions with citations to the record is telling. The letter and emails Peterson himself attached to his new trial motion show the reasons Holly did not try the case and ultimately withdrew. She was engaged in a lengthy 7-month arbitration. She was not comfortable with the defense blaming Harris for the shooting. And 3, after Harris's statements were introduced at trial, she concluded she had a conflict. Nothing in the record supports Peterson's allegation that prosecutors opted to lull Holly into a false sense of security by deceptively assuring her they did not believe her to be involved. The trial court did not err in imposing the midterm. Peterson contends the trial court reversibly erred in declining to impose the lowest possible term. Also, he's saying, man, y'all should have gave me less. Peterson's sole claim of error on this point is that the court found true the aggravated factor that the victim was particularly vulnerable within the meaning of Rule 4.421A3. The trial court found 4 factors in aggravation: that Peterson used a weapon in the commission of a crime, that the victim was particularly vulnerable, Peterson's conduct toward the victim after the shooting between the time of the crime and the trial nearly 2.5 years later, and the fact that the court could have sentenced Peterson to consecutive time to count 2, having a concealed unregistered firearm in a vehicle. The court found 3 factors in mitigation. Peterson had no prior record or an insignificant record of criminal conduct. Peterson had actively participated in actively had participated in charitable and philanthropic causes, and Peterson had a low likelihood of reoffending in a violent manner. The court noted the balancing of the aggravating and mitigating factors was not a mathematical calculation, and some of the factors were much more important to the court's decision than others. The court did not place great weight on the use of a firearm factor, as it was inherent to counts 1 and 3. With respect to the aggravating factor that the victim was particularly vulnerable, the court stated that term includes being defenseless, unguarded, unprotected, or otherwise susceptible to the defendant's criminal act to a special or unusual degree. The court continued, in determining whether someone was particularly vulnerable, you have to consider all of the circumstances surrounding the commission of the crime, including the characteristics of the victim and the manner and setting in which the crime was committed. And it is not enough for the victim to be in the wrong place at the wrong time. Meaning, you shot her on purpose. It's not like you was shooting and then she happened to walk into the goddamn bullets. The court noted defense counsel had argued Pete was not young or small in stature or elderly or somehow otherwise limited. The prosecution, the court said, argued Pete was clad in a bathing suit with her back turned. She was unarmed at the time, and she had no idea that this would happen. Also, she was in an unfamiliar area. In addition, it was dark and early in the morning, with nowhere to escape to. After hearing further argument from both the defense and the prosecution, the court concluded the prosecution had proven beyond a reasonable doubt that the victim was vulnerable within the meaning of the rule. The court viewed Peterson's post-incident conduct as a major factor in aggravating in this case. With respect to the mitigating factors, the court found Peterson's participation in charitable causes not to be a very significant factor. The court said the fact that Peterson had been an asset to the community and had helped people out was not a recognizable factor in mitigation, but was important nonetheless. Similarly, the court stated Peterson's low risk of violent recidivism was not a major factor, but a factor. The only one of these findings Peterson challenges on appeal is the vulnerable victim filing, which is she's turned around in a goddamn bathing suit with no strap. You out your damn mind. Referring to Harrison's statement to prosecutors that she saw Peterson reach towards the center console after threatening to shoot her. Peterson contends Pete should have recognized there was indeed signs that an armed individual may be in the vehicle, and thus had the ability to run duck when she saw the gun being pointed. Nigga, is you serious? They said, well, shit, you knew a gun was there, and you knew he was crazy, so why didn't you get away from his crazy ass? This is insane. We find no error. No shit, Sherlock. Substantial evidence supports the trial court's true finding on that aggravated factor. Moreover, even were that not the case, no resentencing would be required. The middle term of the presumptive term, the court was not required to rely on any aggravating factors in selecting the middle term. And Peterson does not dispute the presence of 3 of the 4 aggravated factors. That's hilarious. At the trial court was required to do in selecting the middle term was to state its reasons. No ineffective assistance of counsel or cumulative error. As we find no ineffective assistance with counsel or prejudicial trial court error, we also find no cumulative error. Disposition. We affirm Daystar Peterson's conviction not to be published in the official reports. Edgerton, J. We concur. Edmund, P.J. Adams, J. End of reading. Subscribe, turn that bell to notify, share to keep your people aware. I'll catch you on the next one. Reloaded.